I'm investigative reporter Jennifer Titus. Just got my hands on the final investigative report from the Sarasota Police Department regarding their investigation into a potential threat with a basketball court down in the city. So this all started after a friend received some text messages. She alerted the city of Sarasota, who then alerted the Sarasota Police Department. That's when this investigation began. They quickly looked at the text messages. I'm going to read you guys some. One saying, "I am afraid it will get violent soon." Another saying, "So someone or many are probably going to die, and I'm not being dramatic. I can't control this." Now, both of those, it says threats chargeable under the written threats to kill statute must specifically threaten to kill, do bodily harm, conduct a mass shooting, or an act of terrorism in a specific way. The phrase "probably gonna die" is too general to charge under that Florida statute. Another one said, "I'm getting a gun and a gun license, and if anyone comes on our property to fetch a basketball, then they can expect me to protect myself against trespassing." This phrase, it mentions that the defendant would be attaining a firearm. Now, that defendant can legally own a firearm, so there's nothing illegal about her getting a firearm. The issue in this phrase arises from the caveat that an individual would have to come onto her property, at which point she would protect herself. Notwithstanding the possible validity of this theoretical self-defense claim, this is not a written threat to kill. And again, why no criminal charges were brought in this case from any of those text messages. They interviewed her, they interviewed the friend that received these text messages, and they also interviewed people within the city of Sarasota, especially right there near those basketball courts. They came to a conclusion that those text messages were not threatening enough for any criminal charges. We'll put more of this investigation on our website right now at 10tampabay.com.